Hey, you got a fun weekend planned, maybe at a friend's house, or maybe you're hosting a party. Well, today's Know the Law segment with Sinus Law Firm focuses on what happens if you're injured on someone else's property, or vice versa. What does Michigan law say about those cases? Well, attorney Tom Sinus from Sinus Law Firm is here to break it all down. Good morning, Tom.
Good morning, Todd. Nice to see you.
Nice to see you as well. Let's start with the basics. I think this is called premises liability, right?
Yeah, it's a funny phrase, not one that you would hear someone say probably casually. You might hear the phrase slip and fall, which is also not that helpful. Maybe it's more common because these type of cases encompass more than just people slipping or more than just people falling. But the concept of premises liability refers to generally when someone is injured on another person's land or in another person's home. And that can be someone that was invited into the home or onto the land, or someone who was permitted to be there. And the question in these cases is whether or not the person who was injured was exposed to what we would call an unreasonable danger. And if they were, then perhaps the landowner or someone else in control of the property may have liability for the injury sustained by that other person. So that's the general concept here.
Okay, and of course, we're all friends until somebody gets hurt, right? And then the courts get involved, and then there's going to be somebody to blame. Michigan's premises liability laws have changed recently, is that true?
Yeah, they've changed significantly in the last couple of years. So let me kind of give a quick of an overview as I can so people understand this. One of the most basic concepts of any personal injury case is the idea of what we call duty, meaning you have to show the existence of a legal duty between the person who was injured and the person who may have caused the injury. So a classic example would be, a lawyer owes a client a duty, a doctor owes a patient a duty, a driver owes another driver a duty. And that duty generally is a duty to act with reasonable caution or reasonably safe. And if you can show that that duty was breached by someone acting unreasonably dangerous, then you've created the next thing you need to show, which is what is sometimes called breach or sometimes called negligence. So that's a general concept. It applies across the board in personal injury cases. All right, what does that have to do with premises liability? Well, up until about 2 years ago, we had a rather strange rule in Michigan, strange in that it wasn't shared by many other states around the country, where the courts had held that if the person injured was injured by something that was known as open and obvious, then the person who may have caused the injury owed no duty. Okay, what does that mean? Translated into regular speak, it means that if the person who was hurt by something that a judge later found to be open and obvious, then the person who was hurt had no legal recourse. Which was kind of odd because it created this situation where the more dangerous and the more harmful, as in the more open and obvious it was, then the easier it was for the property owner to get off the hook. Okay, so what happened? Well, 2 years ago, the Michigan Supreme Court overruled that concept, overruled that open and obvious law, and took us back to law that we had before the 1990s and law that's pretty much shared around the United States. And that does away with this open and obvious rule, at least in terms of it doesn't permit a judge to just dismiss a case because the judge found that this thing that the person fell on or fell into was open and obvious. Instead, we go back to a normal rule that says if you own a property or you're controlling a property and you let someone on the property or in the home, you have a general duty to prevent them from being exposed to unreasonable dangers. And so now we're back to a general kind of duty rule. This question, though, of whether somebody was hurt by something that they should have seen is still relevant, meaning that if the case goes to court and a jury hears the facts and thinks that the plaintiff was careless, and maybe too careless, then the jury can assign what's called comparative fault to the plaintiff, and that may either reduce the plaintiff's recovery or give them no recovery at all. So that's a long-winded way of saying we've gotten rid of this strange open and obvious rule, and we move back to kind of a general personal injury, what some lawyers would call tort rule that we have now shared with most of states around the country.
And with those changes, do people need to take action to protect themselves when it comes to that liability?
Well, it's a great question. This area of law, as you can gather from this short segment, is still obviously in flux. It's not something that is easy for an injured person to kind of analyze on their own. So I think the general idea here, as you and I have talked about before, if somebody's hurt and they're hurt on someone else's property or in someone else's home, it's wise for them to contact a lawyer and at least get that free consultation that, our firm offers, for example. And maybe a lawyer can help them, maybe they can't. But it's hard to kind of work this through on your own without someone who knows the lay of the land when it comes to the law here. So that is good advice, whether it's a car crash or what we call premises liability, but it's especially true here. Because just because we've gotten rid of this open and obvious rule does not mean that if you're hurt on someone's property, you automatically have a claim. You may have a claim, but you also may not. You have to show that what you were injured by is something that the law would call negligent. And that obviously depends on the facts and circumstances of each case.
And those facts and circumstances on each case are so unique. So obviously it makes sense to reach out to someone if you're in this situation, if you find yourself in that type of situation. And for that, Sinus Dramus Law Firm is waiting for your call, 616-301-3333. Or you can always visit sinusdramus.com to have those questions answered as well. Tom, thanks for the time this morning.
Thank you for having me.